Cybercrime and the application of the law and procedure in Ghana. So for this presentation, we will be using the website again. So if you can click on the menu Cybercrime, and then you'll see towards the bottom the heading Guides, and if you can click onto the Cybercrime guide. Now this is a guide that is being prepared applying your law and procedure. So I'm going to do a whistle-stop tour through the guide so you can see the main reference points and how it will aid in relation to not only exercises through this workshop, but I hope in relation to your cybercrime investigations and prosecutions. So if you can please open the guide and go down to the glossary section starting from page 9. And what we have included within the glossary are the major terminology in relation to cybercrime and also in relation to basic points for international law. So you will see the definition of accession there, and equally later on in relation to ratification. But then we go straight into terminology for cybercrime, basic subscriber information. Very important in relation to securing information about somebody who has signed up to use a communication service provider service. So who is the subscriber in relation to a Facebook account? Who is the subscriber in relation to a WhatsApp account? So that will be potentially the name of the person who has signed, how long the subscriber has been using that service, and potentially in relation to when they first created the account and where they logged in from. We then have other references in relation to botnet. And what I always find useful, and I hope you will too, is that sometimes we may not be confident with asking, well, what actually is a botnet? Well, here we have the definition in this glossary that you can quickly turn to as a reference point. So it is a network of compromised computers, or zombies, that will take out specific actions in relation to cyber attacks. And often these zombie computers are controlled without the knowledge of the compromised user by another computer. And that may be from a command and control center. But that is the definition of a botnet. Cloud computing. And we're increasingly seeing the use of cloud computing for remote servers hosted in other jurisdictions in relation to the use of communications service provider evidence. Well, what is a communication service provider? And there is a definition there. And equally within, and we'll be looking at your Electronic Transactions Act number 772, and there's reference to the definition of a service provider there under section 144. So remembering that when the definitions are in the glossary, they will also refer to your domestic law and procedure. So reference there to a computer. And going on to page 11, what is the dark web? We often hear about the dark web. Well, it's actually a small part of the deep web, where the World Wide Web, and it's not using part of the search engines that we would ordinarily use, such as Google. So the dark web will be part of the deep web that isn't indexed by Google, for example. DDoS. Now this will be relevant potentially in relation to exercises that you do. So what is a DDoS? So first of all, understanding what a DOS is, denial of service attack. And that's an attempt to render a computer system unavailable to the users of that computer system. And that can be done through a variety of means. It may be that computers are targeted with the saturation of material through spam material, for example, and inundating them with material will render them unable to be used. So imagine a post box and somebody is just stuffing post after post, letter after letter, package after package, until the postal box is full and can no longer be used. Well, exactly the same in relation to a denial of service attack. So that website can no longer be used because it's inundated by requests, which may be legitimate, but it may be that they are being harnessed through a botnet, through controlling other computers to send these requests. And by bombarding the server, it's overloaded and therefore can no longer be used. Why is that dangerous? Because it may be that it's being used by cyber criminals to attack critical infrastructure, such as government websites, military websites. It may be in relation to hospitals. And of course, if there are DDoS attacks, then those cyber criminals may well say, I'll continue it and I will take down your website through the overuse of it, and I'll continue to do it unless you pay a ransom, or unless you pay me something that I will stop doing this attack. So a DDoS will be the distribution of that denial of service, and that is ordinarily through the use of botnets rather than through one single computer, multiple requests and access and denial of service are sent through the overloading of the information. So I hope you'll be able to see that the common terminology that is used in relation to cybercrime is referenced within this glossary. Another point is metadata. What is metadata? We might hear that phrase in relation to not only my presentation but others. And this will be the data that explains other data. So for example, you may hear reference to content data. So if I send an email, the content of that will be the actual message. But I may only need access to the time that was created. Who was the author? And where was it sent to? So that is the data about the content data, in other words, metadata. You may also hear reference to traffic data. So again, that's the record identifying with whom a subscriber, so we've done the basic subscriber information, and now we want to know who that subscriber communicated with. This can be very important in relation to proactive investigations, finding out where somebody is communicating with, because then we may be able to access their property through a search warrant and making sure that they can no longer continue with their criminal activity. So being proactive rather than reactive. So very useful maybe to determine what websites a subscriber has visited, and equally other information about their online activity. I want to find for you another interesting phrase that may be terminology that may be used. IP address. So an IP address is an internet protocol address, and every computer will have their own IP address. Essentially, it's the address that I am using this computer from to upload to YouTube. So an IP address serves with two principal functions. It's the host or network interface identification and location addressing. So the host or network is who am I hosting this particular link with? So where does it go to on YouTube, and where am I doing it from? So very important for proactive investigations to determine that type of evidence. Where am I producing something from, and where is it actually being hosted from as well? So two important aspects for cyber investigations: an IP address. So please feel free to go through in relation to that glossary. I then, in the introduction, I give a global perspective in relation to cyber criminality and reference to the fact that in Africa alone in 2017, 5 countries were said to have had a combined $895 million lost to cybercrime, and Ghana accumulating 50 million in losses alone. You would have already heard potentially in relation to the statistics in relation to the use of the internet by the world, and there are huge numbers that are talked about. In Ghana alone, it's approaching 8 million, which is a penetration rate, i.e. compared to the rest of the population of Ghana, the 8 million, of almost 30%. And the average Ghanaian spends not less than 3 hours 30 minutes browsing the internet on his or her phone, and 3 hours 13 minutes of that is on social media. So imagine how criminality has changed. So from being outside, now we're inside, or we're accessing our phones in other locations or social media. So there is a new arena for criminals to be able to attack and access our private data, to be able to mine and garner other information to be able to carry out financial crime. There is a huge opportunity here because of the way our lives have changed and our accessibility to the internet and the data that is collected about ourselves through our interaction on social media, whether it be our IP address, where we may be tweeting from or WhatsApping from, and who we're in contact with. Now, in relation to the international dimension of cybercrime, there is only one convention which deals with cybercrime. Now, you recall from the presentation in relation to conventions, the conventions are there so signatories, those who have ratified, acceded, have the same obligations in relation to criminality and also their definitions within their domestic law, and also tools to assist in relation to international cooperation. Now, the very nature of cybercrime is that it is international. It is international. Now, by me having my mobile phone and having access to, for example, Twitter, or even the WordPress website, which is hosted in the United States of America. So therefore, evidence will be located, if it was needed for a criminal investigation, in the United States in relation to my contact with the WordPress website. So now, from what might have been relatively straightforward investigations in relation to standard traditional criminality, have been changed if they involve mobile phones and communication between individuals, or data being stored in other jurisdictions. And now these international conventions assist in relation to the speed, in relation to making sure consistent processes are available in each jurisdiction. And very important to be a signatory to, or ratifying or exceeding these international conventions, because by the push of a button, DDoS attacks can take place from another jurisdiction. Therefore, a traditional law enforcement approach has totally changed. Now, whilst the methodology, or the approach rather, will be the same, that I, as an investigator, need to ensure that I preserve the evidence, but how do I do that? By a push of a button in another jurisdiction. Well, this is where the international conventions become so important, and the tools that they provide in relation to speedy, not just reactive, but proactive investigations. The relevance in relation to the Budapest Convention, which is the Council of Europe, who have drafted and implemented, is that Ghana has been invited to accede. So the date for signature has expired, but now the Council of Europe have invited Ghana to accede. And in that respect, there is a time limit by which that must be done. But if it is done, then Ghana will have access to other jurisdictions that have ratified the convention. The guide goes through other conventions that are available as well. One that is of relevance to Ghana is the African Union Convention on Cybersecurity and Personal Data Protection. And this is a different convention to the Budapest because it misses for most offences the mens rea that would criminalise the legitimate conduct of law enforcement authorities accessing computers for proactive investigations. Equally, it doesn't have the full set of procedural powers for investigating and prosecuting cybercrime, and doesn't form a legal basis for international cooperation for investigating and securing electronic evidence. So it is different to the Budapest Convention, which does have the mens rea elements, and equally in relation to the investigative powers. Also remember the application of other international conventions, and they would include the United Nations Convention Against Transnational Crime. Now, of course, there has to be the fulfillment of the definition of transnational organised crime, but that's generally applicable to cybercrime because there will be more than one person involved, and a organised crime group is a structured group of 3 or more persons, and it has to be transnational and for a material benefit. But just in this short time, how I've explained in relation to cybercriminality being usually transnational in nature and often will be multi-parties, and equally in relation to it being for a specific financial purpose. Then there is UNCAC, the United Nations Convention Against Corruption, and again that will have the basis for international cooperation under Article 46.7. If there isn't a bilateral treaty, then again UNCAC can be used. Equally within UNTOC, the United Nations Convention Against Transnational Organised Crime, Article 18, again both conventions can be used for the investigation on an international basis in relation to cyber criminality. Look please at the status list which you have on the website under the conventions page on the menu, and you can see those states that are parties to. Very important in relation to spontaneous information. Spontaneous information. So under UNCAC, please look at UNCAC under Article 48, and in relation to UNTOC under Article 18.4 in relation to the spontaneous provision of information. Very important in cyber cases to ensure that information, because it's being passed so quickly between cyber criminals, your law enforcement may garner that information, but it will be quicker rather than sending a mutual legal assistance request to send the information immediately to the other law enforcement in the other country to investigate, whether that be by use of a special investigation technique to intercept transmissions between computers, or maybe to freeze the proceeds of crime. But very important to consider. From page 25, I go through computer technology. And again, this is at a very basic level, and you would have seen it in other presentations through the workshop in relation to how digital material is stored, and equally then in terms of how it is transferred, and then data handling. Very important in relation to securing the evidential integrity and reliability of evidence. And again, you'll see this through those practitioners in Ghana that will Explain about what you do if you see, when you go and do a house search, a computer that's on. Is it turned off? Is a photograph taken if somebody is live streaming at that particular time? What do you do to ensure the integrity and security and reliability of the evidence that you secure? Remembering these are all the essential points that any investigator would consider for any investigation. But for cyber investigations, there will be different techniques that should be deployed. And remembering our overall methodology in relation to these workshops is to encourage prosecutors, state attorneys to be working at an earlier stage with investigators. So when you're planning your search warrants for a property and you're looking at cyber cases, or you know there may be digital evidence, have you discussed in terms of ensuring the integrity of that evidence, the admissibility of that evidence? So thinking about if there is intelligence that a computer is in the location where you're going to search under Section 88, securing a search warrant under Section 88 of your Criminal Procedure Code 1960, Act 30. Have you considered what we will do? A prosecutor can assist, saying, well, if the situation is that a computer is on, this is what I want you to consider in terms of admissibility in relation to that evidence. So if you possibly can, in terms of securing it, this is what you should do. And again, the guide at this point provides a very basic level in terms of what could and should be done. Encryption. I'm going to do another separate presentation in relation to encryption and international inquiries, but again within the guide there is reference to what encryption means. The guide then moves on at page 31, investigative powers. And this is where I've said about case management, and because of cybercrime being sophisticated and technical in nature, potentially inquiries overseas, this is why it's very important that a prosecutor, state attorney is fully briefed in relation to the investigation at its proactive stage, so that you can work together to ensure that the evidence that is accumulated or obtained or secured is in a robust form to be admissible at any court trial. Joint investigation teams. Again, your Mutual Legal Assistance Act allows for joint investigation teams, JITs. Very important. These are teams that are established between two different states or multiple states, and they work together to share information directly, intelligence or otherwise, and equally in relation to sharing of specialised knowledge. And then you build trust between these two jurisdictions to make sure that your investigative and prosecution strategies are consistent. It may well be that subjects are located in one other jurisdiction and you want to discuss where it would be best to prosecute, but then equally making sure that relevant evidence from Ghana is able to be passed over to that other jurisdiction. Does that have to be by way of a mutual legal assistance request, or by establishing a joint investigation team? Is it possible to share that information so it will be admissible in the other jurisdiction? So you're thinking about the most efficient use of your resources in Ghana, but also to ensure the result that you want in relation to conviction, recovery of assets potentially in the other jurisdiction, and what may come back by way of stolen assets to Ghana. So with that in mind, please note that on the website, and it's located under the International Guide section on the manual, there is a Model Joint Investigation Team Agreement, which will be useful in relation to making sure that any JIT is established with the agreement of both parties. Who is the lead officer? Are there any concerns in relation to a disclosure regime in the other country? In other words, if we provide the information, how can we ensure that it isn't disclosed to a third party that we don't want to have it because of sensitivity? All of these types of points would be agreed before the commencement of the JIT by way of an agreement, and there's a draft model agreement on the website. Investigative tools, extremely important, because as I say, whilst you will be considering any investigation on the traditional approach of making sure that you preserve and secure and the integrity of the evidence, there needs to be a particular focus in relation to the terminology for cyber investigations, but also because data is stored in a different manner. We're not talking about being able to search a computer system. We're talking about being able to access it and to get inside to secure the data. So again, your legislation will refer to the accessing of data, and equally in relation to computers. So under your Electronic Transactions Act number 772, we have the Section 98 power, which is in relation to the use of seizing computers, electronic records, which I'll move on to the definition of, and programs, informations and documents. So we're talking about a different type of evidence that needs to be secured. But please also remember about the Criminal Other Offences Procedure Act, 1960 Act 30, and sections 26 and 27 of the Economic and Organised Crime Act 21 in relation to cyber investigations and the use of those particular powers as well, which can be very important in relation to cyber investigations. So again, this is why the assistance of a prosecutor will be beneficial at an early stage to determine, well, which section, which law do we proceed under? Is it section 98 of the ETA, the Electronic Transactions Act? Or is it section 88 for a search warrant in relation to the Criminal Other Offences Procedure Act? Or is it under the Economic and Organised Crime Act, section 26 and 27? We then move down to page 34, and very important element. As we said, the basic premise of any investigation is the preservation of evidence. But even more important in the context of cyber investigations, when by the push of a button, the data, the evidence can be deleted. So we need to make sure that the evidence is preserved at a very early stage. So, section 100 on page 34. So let's read that. A provider of a wire or electronic communication services or remote computing service on the written request of a law enforcement agency should take the necessary steps to preserve records and other evidence in its possession pending the issue of a court order, and shall take steps to ensure that the request by the law enforcement agency is not disclosed to third parties during the period. So, a written request by a law enforcement agency provided to the communication service provider. Very important, and also the user of that account is not notified within 14 days. So if you do have a communication service provider who is outside of the jurisdiction, then you will need to consider serving that letter on them, and it must be done immediately because of the reasons of deletion. Now, some of the communication service providers, certainly the United States, will not delete material immediately. They will not delete material immediately, but it will eventually be deleted. So you must not delay. Do not delay in terms of the preservation by the law enforcement agency, the written request. And remembering, apply to the court straight away as well, because that 14 days will expire very quickly. Very quickly. So, under Section 104 on page 35 of the guide is the backup preservation. And this, I have written in the comments section, should be applied before the 14-day expiry. It should be routinely done as soon as possible. And then that again can be served on the provider, domestically or on an international basis. Remembering though, on an international basis, the law in that jurisdiction will apply. So in relation to the United States, under their Electronic Communications and Privacy Act, only 90 days allowed for preservation. And then there must be a further request before the expiry of that 90 days to a maximum of 180. And then if a letter of request or an international request is sent, usually you can go beyond that 180 days. But you must be in communication with the communication service provider in the United States, Google, Twitter, or whoever it might be. And with that in mind, please see on page 34 that there is a link to the Guide to Obtaining Communication Service Provider Evidence from the United States. Equally, the guide is within the Cybercrime menu. So on the Cybercrime menu, you will see the guide in relation to Communication Service Provider Guide. It's listed under the heading Guides, and that will assist in terms of how you can preserve and garner evidence from the communication service providers in the United States. So the guide then moves on in relation to mutual legal assistance, and as I say, I'm going to do a separate presentation in relation to mutual legal assistance with the United States. National law. Now from page 40, the guide goes through the Electronic Transactions Act, the ETA, in relation to the cyber crimes that are referenced within that act. Now there are two types of cyber crimes, those that are cyber dependent and those that are cyber enabled. So cyber dependent will be those where devices are used in relation to committing the crime. And then the cyber enabled are those which are used in relation to what we would say are traditional crimes. So for example, your frauds, but it is through a cyber enabled crime. So for example, if a link is put on an email and I'm asked to click on it, so that's phishing, so I'm being encouraged to click on the link, and when I click on the link, that's when access to my data is obtained. And then it may well be that there is a fraud in relation to accessing my personal account. So there are two crimes there. There's the cyber dependent because my data is being accessed, but then the cyber enabled in relation to the fraud to access my bank account potentially. And equally, if it's been sent on a bank headed paper, cyber forgery because I was led to believe that was a legitimate copy. So two different crimes: cyber enabled, the traditional crimes that have a cyber element, and the cyber dependent in relation to accessing my data, or DDoS attacks to prevent systems, computer systems being used. And in the guide, I go through in relation to the different types of cyber criminality, the modus operandi, and the different offences that are included within the Electronic Transactions Act, the ETA. I'll also take you straight down to the points to prove from page 55. So here I have put down definitions and what needs to be proved for different offences within the ETA, cyber-dependent crimes. So let's look at one of those, unauthorised access. So this is colloquially referred to as hacking, so getting into a computer. Let's look at section 124, which I have put out in full on page 55 of the guide. So a person who intentionally accesses or intercepts an electronic record without authority or permission commits an offence, and then it has in terms of the punishment. So what is unauthorised access? So this is defined in section 144 of the ETA. It's access of any kind by a person to program or data held on a computer without authority. So if somebody is sending the link, and then by me pushing on the link they are able to access my personal data, then that is unauthorized access. And by sending the link, they have intentionally done that. So that would fulfill the mens rea and also the actus reus in relation to the unauthorized access. But what is a program or indeed data? So a program is data representing instructions or statements, and that's under section 144. And an electronic record includes data generated by electronic means. So basically data is anything that's held on a computer. And the unauthorized access, please note, is not in relation to accessing my computer, but accessing that program or data. To simply getting into the computer is not an offence unless it is a protected computer under section 118. And a protected computer is set out at page 57. So basically that's when I mentioned about critical infrastructure, and section 118 defines protected computer. Now, under the Budapest Convention, unauthorized access, illegal access, would be to a computer, full stop. It doesn't actually have to be to something inside that computer. So just if somebody accesses the computer and it's unauthorized, without authority, that then is the criminal offence. Not in Ghana unless it's a protected computer. And the unauthorized access is only to an electronic record. So please remember that when considering any offences that are committed in Ghana. So again, I go through in relation to the main offences in Ghana that are cyber enabled. And please, this document is there to be able to assist the prosecutor and also for the investigator when they may be interviewing a cyber suspect, so they know the points to prove, what they have to put in terms of a question to those that they are taking a statement from. Very important, equally in relation to witnesses. So again, I said at the outset how I hope this will be a one-stop shop in relation to all the relevant information that you need to assist with a cyber investigation. Evidence. Admissibility. So very important that section 7 of the ETA presumes that an electronic record is admissible unless otherwise stated in the Electronic Transactions Act. And then a court will assess the evidential weight of an electronic record. And that will take into account the reliability of the manner in which the electronic record was stored or communicated, generated or displayed, and how it was maintained, and how the originator was identified, and any other relevant factors. So very important that when the material is seized, how can we show that that has come from the computer of the victim? When the search takes place, if a suspect turns off their computer, how have we ensured that the material on that computer that we produce as evidence is the evidence that was secured from that suspect's computer? Have we gone to the hard drive? What has been done? Has an expert looked at it to make sure that the integrity and the continuity is still there? It's very important to think about these points at the very outset. Hearsay. Again, considering about hearsay evidence, an important point in relation to hearsay. If evidence is secured by mutual legal assistance, it is admissible in evidence irrespective of the fact that the affidavit, certificate or other statement pertaining to the item contains hearsay or statement of opinion. But it's very important that any statement from that overseas witness is verified on oath. So please look at the Mutual Legal Assistance Act, Section 72, Section 73B, if evidence is obtained from overseas. Then I have also provided in Annex A from page 62 a precedent letter of request to assist with those requests that are going overseas for electronic or digital evidence. And at Annex B, a checklist in relation to the essential points to include with any letter of request. Very important that you know what you want to ask for from the other jurisdiction. And I would strongly suggest that a draft is sent to the central authority so you know what you can or can't get. Don't be disappointed if they come back and say, well, actually, we don't have that reciprocal power, so we can't do it. Don't wait for that to come back as the response. You want to be proactive. Hence why you get the state attorneys on board who will recognise we need to send a mutual legal assistance request to another jurisdiction. Let's contact the Public Prosecutions Division International Inquiries Department, who will then tell us if there have been any other issues with that jurisdiction and what we should do to garner that evidence straight away. And one of the main points in relation to the checklist, preservation. You must preserve straight away. So please remember in relation to, if you remember nothing else from the presentation, it's always about ensuring that you preserve. So I now want to go to the presentation. So the Cyber Basics short version. So this will be on your website. And if you can please click on the Cyber version short. I'm just opening it now. And we are going to go through this presentation. So you can see on slide 1, so after the title page, so it'll be slide 2, there is a message, an email message. And if you have seen the International Conventions presentation, you will recognize this email message that I received in Ghana from Google accounts, saying that I have had a message blocked by the Google bulk email filter and to view my messages or click on a link to learn more. But obviously up the top, if I look next to Google accounts, the sender, I can see hbzwdngs@adet.com as the sender. That obviously is not from Google accounts. That is from somebody who's trying to access my computer, my data. So if I was to click on that link, I would have given them access. So what offence has been committed? Now you will recall that we had the points to prove section. So let's go back up on our cyber guide to see if we can have any assistance in relation to the investigation. Also, whilst doing that, think about jurisdiction. Is jurisdiction okay in relation to this particular offence? So if it's been an offence that has been committed in Ghana, but I'm not a Ghanaian national, and this may be an email that's coming from another jurisdiction, is jurisdiction fulfilled? Is this something that I should be thinking about straight away? Well, Jurisdiction will be satisfied if the accused was in the country at the material time. Well, the sender from aditi.com, we don't know where they are. Have I paid anything? Because under section 142 of the Electronic Transactions Act, if an electronic payment medium, computer or electronic record was issued in or located or stored in the country at the material time, jurisdiction satisfied. Let's come back to that one. If the electronic payment medium was issued by a financial institution in the country, well, I haven't paid anything yet. Or if the offence occurred within the country, on board a Ghanaian registered ship or aircraft, well, I'm not on a ship or aircraft or on a voyage or flight to or from the country. But the electronic payment medium, computer or electronic record was issued or located or stored in the country. So the record was located because that's an email that I received in Ghana. So we could go under that limit. Or if the offence occurred within the country. So now we need to look at the offence. Just so you're aware, in relation to jurisdiction, that will be on page 51 of the guide, setting out in terms of jurisdiction, and also provides some authority from the United Kingdom when there has been an issue in relation to cybercriminality and in relation to jurisdiction. So we want to look at if there has been an offence committed in Ghana to establish jurisdiction. So we had looked at section 124 on page 55. So has there been unauthorised access? Remembering that we have to show intent. So an intent is defined on page 56 as a person who uses any electronic medium or any electronic agent, whether in part or in whole, is deemed to intend to cause or contribute to causing the event which results from the use or intervention of the electronic medium or agent. So that sounds all quite wordy, but basically there has to be knowledge on the part of the accused that the access is unauthorised. Now, by virtue of the fact that that email address is not for Google, we can establish that, can we not? We may need to go to Google to establish that fact, but the simple fact is that you can show that that was not a legitimate email. Think about how you're going to prove that to establish intent. Equally, remembering this isn't access to my computer, this is access to an electronic record. So when you take a statement from me as the victim, you're going to have to find out what happened when I clicked on that link. So let's say I clicked on the link, and as a result of clicking on that link, data has been accessed from my computer. My emails have been accessed as a result. Is that an electronic record? Is that data that has been sent, received or stored by electronic means? Well, certainly my emails are stored on my computer, so therefore that would satisfy, would it not, the definition of an electronic record. And then what the cyber criminals do by getting access to my email account will farm through those details to confirm whether I have had any interaction with the bank or any other personal data that they may be able to ransom me for or prevent me getting access to my email account, which will be very important in terms of the use of my business. So exceedingly important to determine whether an offence has been committed applying your law. Has there been unauthorised access to an electronic record? You may want to consider the section 125 offence of unauthorised interference with an electronic record on page 59. So let's look at page 59. So, section 125 of the guide, it says a person who intentionally and without authority interferes with an electronic record in a way which causes the electronic record to be modified, destroyed or otherwise rendered ineffective commits an offence. So what does the term destroyed or otherwise rendered ineffective mean? basically a negative alteration of the integrity of the electronic record. Deleting is obvious in relation to removing it and therefore putting it into the trash bin. But that doesn't mean that it goes from the hard drive and may not be considered deletion if it can be recovered, but that may be still destroyed, that I can't gain access to it. So you've got to think about which particular actus reus will be applied on the facts of the situation that has occurred with my email. So remember, I've pushed, and then the bad guys have been able to access my email account. Have they destroyed or otherwise rendered ineffective? Well, if they're saying, we want you to pay money in order to get that access back to your emails, then my email account is rendered ineffective, and that is their intention to do that. So please think about that. Equally, there is the generic phrase of otherwise rendered ineffective. So that could cover all acts of interference that I couldn't use the email account for its intended purpose or other data for its intended purpose. So please consider the section 125 offence. Also, consider section 126, access to devices. So a person who unlawfully produces, sells, offers to sell, procures for use, designs, adapts for use, distributes, or possesses any device, including a computer program or component, which is designed primarily to overcome security measures. So what is a device? A device, under section 144 of the ETA, means anything or apparatus that is used or is capable of being used to intercept a function of a computer or electronic record. So this would include a virus to access my account and render it ineffective. So if by pushing the link on that email, I have allowed access to my computer and a virus has gone in, which could be used in a botnet to do a DDoS attack in another computer system, or it is being used to wipe all my data, and then an email is sent to me or contact is made with me to say you can only recover your data if you pay this amount of money, then that is a device, a virus that is entered into my computer. So again, think about what is the actus reus and what has been the intention in relation to the cyber criminal. Very important in relation to this type of offence, dual use. There can be many uses for legitimate products that can be put to legitimate use, but then others which may have an unlawful use. So there may be a program that tests in relation to protecting your computer, but equally that tool could be used to access a computer because it can only test the security by gaining access to your computer. So think of dual use and the intent in relation to the cyber criminal. And I put some common thoughts in relation to assessing the dual use on page 61 of the guide. Another offence to consider on page 61 is section 134 of the ETA, causing a computer to cease to function. So again, this is to protect the integrity of a computer and computer systems. Now, this doesn't refer to without authority. So there is an issue in relation to the mens rea in relation to this offence, which may cause some concern. But equally, it is an offence to consider in relation to the attack in relation to critical infrastructure. So it could apply in relation to a DDoS attack, albeit there is a specific DDoS provision in relation to the ETA, a criminal offence within the ETA as well. So I'm now on slide 4 of the Cyber Basics presentation. So we have the email, we've considered the offence, we're considering either a section 124 or indeed a section 125. What do I now have to do as an investigator? So the state attorney, working closely with the investigator, will say, well, have you preserved? Well, yes, we have preserved the account, and we have done that by way of sending the law enforcement letter under section 100. Well, says the state attorney, have you done a backup? And we need to make sure that we get the court order and we can serve that immediately. Have we considered that we want to make sure that we garner any of the other emails from the victim? So what accounts do we need to be preserving? And indeed, is there any information we can get from the provider in relation to the aditi.com email, so we can show where they're sending the emails from to get the internet protocol address? And that, of course, comes under when we go to slide 5 in relation to mutual legal assistance. And this is very important to consider. So when you look at the guide, you will see from page 37 what can and can't be done. And I'm going to go into more detail in relation to mutual legal assistance, but please look at the emergency request provision on page 38. Please look at voluntary disclosure and what can and can't be done. But if there is mutual legal assistance that is required, then you are going to have to be working very closely with your state attorney and also the investigator to preserve, get any voluntary information, informal assistance, anything that can be done to locate the IP address. Do we have to do that by sending a letter of request? And this is where the communication service provider guide on the website under the cybercrime menu will be of great assistance. Now look, we've also discussed about admissibility. Very important. So again, to remind you in terms of the application of the example. So if you go to page 54 of your guide, remember section 72 and section 73B of the Mutual Legal Assistance Act. If there's hearsay, so if we're obtaining evidence from Google and hearsay is contained within any email that is sent, well, via the Mutual Legal Assistance Act, that evidence will be admissible. So again, very important. And remembering the basis for any electronic document is admissible under section 7 of the ETA. So, slide 7. I want to give an example in relation to how I have conducted a cybercrime prosecution. So on slide 7, you'll see a prominent personality called Gordon Ramsay, who's a world-renowned chef, done a lot of TV programs, not only in the UK, but also in the US. And he was the chairman of Gordon Ramsay Holdings Limited. And there was a cyber attack or a hack in relation to his email, so unlawful access, illegal access of his computer. And it turned out that it was his father-in-law who had previously been the executive director of Gordon Ramsay Holdings Limited. And he had actually been sacked or fired by Gordon Ramsay, and in a vendetta had sought to access the email of Gordon Ramsay because it contained personal information that he could say and use against Gordon Ramsay to the media because of his famous personality. And that's indeed what he did. He accessed his email account and also other employees of Gordon Ramsay Holding Limited with other members of his family. They accessed over 2,000 times the email accounts of Gordon Ramsay, his wife, and other employees. The investigation had been going on for some 4 years. And when I reviewed the evidence, I saw that the expert who looked at the log frames, so the log frames would show who had accessed any email account and from where, so it would show the IP address of where somebody was located when they accessed the email account. The expert was somebody who had worked for Gordon Ramsay. And looking at the integrity and the reliability of that evidence, my view was that under cross-examination, if defence counsel were to say, well, are you still being paid a retainer by Gordon Ramsay, then it may look as though the evidence was one-sided, it was biased. So we needed to get an independent expert to look at the log frames. And when the independent expert looked at the log frames, they were able to support the evidence of the Gordon Ramsay expert, but equally saw a wider hacking operation that was being undertaken by Gordon Ramsay's father-in-law and the other co-conspirators. And therefore we had a robust prosecution case to show how the access had been obtained, and equally to show the widespread nature, that this wasn't just targeted at Gordon Ramsay. What further complicated the investigation and prosecution was that Gordon Ramsay decided that he no longer wanted to support the prosecution. So he was no longer willing to give evidence. At that point, the prosecution, Queen's Counsel, was nervous in relation to whether we could prove the unauthorised access. Did we need Gordon Ramsay to give evidence to say that he did not consent to access to his account, and equally the other victims in relation to accessing of their accounts? My view was that no, you didn't need that, because you could show the IP address coming from another location that clearly wasn't the address from where we knew Gordon Ramsay was located. Indeed, we didn't have to have Gordon Ramsay to show that that hadn't come from that address, but what we could show was that it came from the home address of the accused. And therefore we had clear evidence in relation to unlawful access being undertaken by the accused. So we charged a conspiracy in relation to unlawful access, and the defendants pleaded guilty, and the main conspirator, the father-in-law, was actually sentenced to prison. But the emphasis with this approach was that I was working very closely with the investigators, discussing admissibility, integrity, and what we needed to do to ensure a successful prosecution with admissibility of evidence. And these were points that we needed to discuss before charge, in order that we knew that we were prosecuting the right individuals and the prosecution case was robust in how we would present it. Now, the facts were fairly straightforward, but the evidence was voluminous, and we needed to make sure we were presenting the evidence in as simplistic a style as possible and in as persuasive a style as possible to ensure that our case could be properly presented, and therefore forcing the accused into a position where they had no choice to turn. And by top-ending that at the start of the investigation and prosecution, we saved ourselves a lot of time down the line and ensured we had a successful outcome within weeks of having charged. So I hope the guide will be able to assist you in relation to the questions that you need to ask. Of course, it won't cover every point, but I hope it will be the headline issues for you. In relation to one last slide, on page 8 of the short version of the Cyber Basics presentation, I have the Global Prosecutors eCrime Network. Now, this is a website hosted by the International Association of Prosecutors. So for all of you who are members of the International Association of Prosecutors, the IAP, they provide a password to be able to access this particular website. It provides a whole host of information, and if you went to the guide on page 24, you will see that material that's provided, a library collection of cybercrime material. So, and from the Council of Europe, a discussion forum. So if you don't have the answers in the guidebook, discuss with another practitioner, maybe from another jurisdiction, but many of the issues for cybercrime have some commonality. And equally, contacts for those prosecutors around the world should you have an investigation or prosecution involving another jurisdiction. I can't emphasize enough how brilliant that website is, but you will need a password and be a member of the IAP. So please contact the IAP. Even if you wanted to maybe give it a trial run, they may be able to assist with that. I don't know, but it's certainly something of value that I would certainly endorse. So that is the end of this cybercrime presentation. We have, to recap, covered your law and the offences under the ETA, procedures in relation to investigations and investigatory tools, remembering preservation as a key, and also the backup, some international aspects, but I'll speak in more detail in another presentation on international aspects of cyber criminality and in securing evidence, and of course in relation to the glossary of terms to be able to assist you. And remember, use the tools. So for some of the exercises, the answers will be in the guide, so you have practical application in relation to the use of the guide.